Good morning, everyone. I welcome you all to this webinar on essence of estate planning, organized by cPROFIT. A lot of efforts made by Vanitha to connect you all during this time where there are a lot of constraints connecting with the people with technology, and most of us are not so accustomed to use the technologies, and all these are new technologies. But all the efforts are made to make it effortless and convenient to you all. So in case of any technical glitches, please hold on. We can also connect you back one-to-one if necessary. I also congratulate you all because the next 60 minutes time you have taken is for the well-being and welfare of your family members. What I'm saying is that today we have experienced the different quality of life which we have been longing for years and years. I hope you all agree with me that there is a big shift, like a North Pole to South Pole. There is a big shift the way we have been living in the post-COVID, right? So we call now BC and AC, before COVID and after COVID. There's a big difference in our lifestyle. Just introspect yourself, why you have been so busy before this lockdown. What for? What we want to achieve? What is the benefit we are going to derive? I'm sure in everybody's mind, it is about yourself and your family, and then society. So we all have responsibilities. We have certain obligations. So to fulfill these responsibilities and obligations, so we are engaged in income earning activity, generate income, use money, and surplus money we save and invest with the help of the advisors and professionals. Nothing wrong with that. That is what we are into. That is only one part of activity which we are doing or we have been doing to provide for the welfare of the family members. But if any unfortunate event happens, like we are experiencing now, do we have made enough arrangements so that our family members will have access and complete control over our asset and investments which are made for their well-being? So most of my experience, most of the people, they just focus on creating wealth. The more wealth they have, the more happy they are. But they fail to understand that this wealth is not just for themselves to keep in a mutual funds or in equities or somewhere. This wealth should also be made available to the family members when they need it most. How do they get access? How do they get the rights to use this money for their well-being? That is what is the essence of estate planning today. I'm sure you are going to be with me now for the next few minutes, and I am completely confident that you will get sufficient inputs that will help you to have a proper succession plan for the benefit of your family members. Right? Shall we go ahead now? Right. Now, today we'll try to answer these three questions. Do you know what you own it? What you own? Do you know what you own? I'm a practicing estate planner. I did not give introduction about myself much because we lost some time. I thought we'd use the time effectively for our topic. So what you own? I've been doing these seminars and workshops over the last 3+ years. In every seminar, I ask this question, wantedly, purposely, to gauge how people are prepared with their finances and assets. Believe me, 80% of the people does not have a proper record in one place which captures all the assets or estate they own. I'm sure you can also ask this question to yourself. If something happens to me, whether my family is aware what are all the assets and estate I own? Is this record is in one place? If it is yes, I appreciate you are in the right direction. If it is no, today is the time you must take a decision to ensure that all the estate flows to the benefit of the family members. So what you own, you have what you own is nothing but the assets what you own. So this could be bank deposits, could be FDs, could be your gold jewelry, it could be your house property, it could be invest in mutual funds, equities, bonds, debentures, anything which has a value. So all these are the assets you own. But again, generally, we don't give the purpose and direction for the assets what we own. We may have investments in mutual funds, we may have investments in equities and other asset class, but we don't know why we are investing. Or even though we know investing, we have not assigned a particular investment for a specific goal. That is what the question next is, why you own it. Yeah, I started an SIP in mutual funds or equities, and I've been investing and creating a corpus. The purpose here is to provide funds for my child's education when it goes for the higher education, 18 years or 20 years, at the age of 18 or 20. And another 10 years for him to go for this higher education. If something happens to me, the investments which I have created or the insurance policy which I have taken, something happens to me which gives compensation for the benefit of my child's education. Have I made it enough arrangements that this money will go only for this purpose? You also would have come across in many families, when there is a loss of a family member, all their financial discipline or whatever they have, if the same discipline is not continued after, because proper provisions are not made. So it is equally important why you own it. So when you know what you own, when you know why you own, then it will be easy for us to answer the next question, who will own it going forward? So if I made provisions for my daughter's marriage, these funds should be utilized only for my daughter's marriage. If I have a property where I want to provide security to my wife and my mother or my parents, I should make enough provisions that my wife only will have a right on this property. If I have made provisions of investments for my son's education, I should make provisions in such a way that these funds will be used only for my son's education. In the absence of these provisions, the future of these children, let us say if I don't make any provisions, my son may not have enough money to continue education when they need it most. We have come across in our life, if you look into past 30, 40, 50 years, in most of the families, when there's a loss of family member, a very bright member of the family, child of the family could not pursue his education because of lack of finances or resources. So these are three questions we need to answer to ourselves: what you own, why you own it, who will own it. Once you know answers to these questions, then it is easy for us to make proper provisions so that whatever assets you have created with your hard-earned efforts will be utilized optimally. So in general, these are the assets that we all own, right? Just for your visual this one. Now let us ask a question. Who owns my real estate after my life? Who owns my bank deposits after my life? Who has a right on my stocks, debentures, mutual funds, gold, car, all these assets? Who have a legal right to own it, use it? As the next question comes. There are many myths about the inheritance. Today we will try to uncover these myths, right? So when a person leaves this world, all his assets will normally expect to move to their family members, what we call inheritance. So inheritance is nothing but transfer of assets after the life of a person to his family members or legal heirs. This is what is called inheritance. This inheritance can happen in two ways. So either you decide who has a right and ownership on the assets what you own, or you allow the law to decide. These are the only two options. Either you decide or allow the law to decide. There is no other alternative. When you decide about the transfer of your estate of your life, it is known as testament. When you don't decide, then law will decide. This is what is known as state of intestate. Here, the default option is intestate. If you have not have any proper plan, then the default is intestate. Law will decide. That means you are not deciding about the management of your property. You are allowing the law to decide, and you are not giving the right to your family members to decide. I'm sure nobody would like the law to manage the property and distribute to their legal heirs. So since the default option is intestate, let us see what the law says. What are the provisions made by the law? So here in India, we have 3 succession laws which determines the rights and obligations of the family members to inherit the property owned by a person. These 3 succession laws are Hindu Succession Act, Indian Succession Act, and Muslim Personal Law. So Hindu Succession Act is applicable to Hindus, Buddhists, Jains, and Sikhs. Indian Succession Act applies to Sikhs, Jews, and Parsis. And Muslim Personal Law is applicable to Muslims. So when a person dies intestate, that is without any estate planning or succession planning, that is what I mean to say intestate. So when a person dies intestate, all his estate or assets will be distributed to their legal heirs as per the provisions made under these respective laws. So let us say what the Hindu Succession Act says to begin with. Hindu Succession Act has made a provision separately for the assets owned by male and female. It is not the same for both. It is different for male and female. So every legal heir of Hindu male is classified into 3 categories, what we call class 1, class 2, and residual. The legal heirs of a Hindu male, when I say Hindu, it includes Hindu, Sikhs, Buddhists, and Jains. Okay. Every legal heir of a Hindu male is classified into 3 categories, class 1, class 2, and residual. The class 1 legal heirs of Hindu male includes his mother, wife, sons, and daughters. Mother, wife, sons, and daughters. So as per the Hindu Succession Act, when a Hindu male dies without any testament or estate planning, as per this act, all his estate belongs to class 1 legal heirs equally. Suppose if I am a Hindu, if I die without any estate planning, all my assets shall belong to my mother, my wife, and children equally. They have a right. If my son has predeceased already, then the share of such son will go to his branch, that is son, wife, and daughter, and so on. Only his share. They don't have equal rights to participate, only his share. So these are known as class 1 legal heirs. So here, let us see the positive and negative of it. The positive side I take, let us say there are no disputes among my family members. They all live together harmoniously, including my parents, my wife, and my children. I have a house property. I have my financial investments like equities, bonds, debentures. I have a car, some gold, jewelry, and all. These are the assets owned by me. So financial assets, let us say my wife is the nominee. She gets all the proceeds from the financial institutions. And my mother and my children did not create any dispute there, absolutely fine. The money is a movable commodity which can be shared with the others. But the challenge comes about the house property. For some reason, tomorrow my wife don't want to stay in this property. She wants to relocate to different place. Now they would like to sell this property. and I am the owner. I am not here now. She will have a difficulty to sell it. Because after my death, as per the law, it belongs to my class 1 legal heirs. It's not only that my wife can take a decision, even my mother, my children, sons and daughters, everybody should agree. Yeah, they may agree. But the challenge comes to prove who are all the family members or who are my children. Whether I have only one son or two sons, I have only one wife or other wife, or how many daughters I have. So there must be a proof about my family. Then we need to have a succession certificate, what we call legal head certificate or family tree. Different states have different rules. So these are the complexities that arises even though there are no disagreements among family members. But imagine if there's a disagreements, it takes years for the family members to access these wealth. Today, I was told by one of my legal friend lawyer that most of the cases, more than 60% of the cases in the civil courts are property disputes among the family members, or disputes due to the disagreement among the family members. These disputes could have been avoided if proper estate planning is made. If not avoidance, at least we have reduced to great extent if proper estate planning is made. Right. So what is about class 1 legal heirs of Hindu male? If a Hindu male does not have any class 1 legal heirs, then all these assets will go to class 2 legal heirs. But there are many class 2 legal heirs, but these legal heirs will have a right in the order of succession. They don't have an equal right like class 1. So first in the order in class 2 is father. So in the absence of class 1 legal heirs, then father being a first in the order in class 2, he will have absolute right on the property of Hindu male. So here you look into the funny thing. I have a right to inherit my father's property, but something happens to me. My father does not have any right to inherit my property. So this is where estate planning is important. In a case where parents, especially father, is dependent on the children financially, if any unfortunate event happens with his son or a child, father will not have any financial security. He doesn't have a right, as per the provisions of law, to share this property of this son. I'm not going to the other legal rights because it's too lengthy. We don't have much time today. So I'm just going to the core and important topics. What is about the inheritance of a property owned by Hindu male. Now we'll come to Hindu female. When it comes to Hindu female, there are no class 1, class 2 like in Hindu male. There are only 5 categories which are in order of succession. The first in the order for the inheritance of Hindu female property is sons, daughters, and the husband. If a Hindu female dies, her property belongs to sons, daughters, and husband. If these sons, daughters, and husband are not there, then it goes to the legal heirs of the husband. When I say husband, he is a male. Legal heirs of a Hindu male are mother, wife, and children. Of course, when wife and children are not there, it goes to the mother of the husband, that is mother-in-law. If there are no legal heirs of the husband, then it goes to the parents of the Hindu female. So parents of Hindu female have a right only the third in the succession. They are in third in the succession. But one point here we need to look into is that when Hindu female dies and owns the property, so other factor we have to look into that. If she doesn't have a children, then we have to see how she acquired the property. This is only when the Hindu female doesn't have a children, we have to see the source of acquisition of the property. When Hindu female dies without children, and if she got any property from her parents before or on the occasion of marriage or after the marriage by way of gift or Sridhan or whatever you call, such property will be, rights will go back to the parents. It does not go to the husband. So husband of a Hindu female will have a right to share her property only when they have children. The husband can inherit the property owned by Hindu female if she has received from the husband or from parents-in-law. Such property will go to the husband. Otherwise, any property which she got from the parents and she doesn't have a children, parents will get back their rights on the property as per the law. So this is what is about legal heirs of Hindu female. So now we have understood that how complicated the law is. First of all, when a person dies intestate, the first need that arises is to prove who are all the legal heirs. So what is the proof? You can get it in a place like Bangalore or Karnataka, or more so in Bangalore. So one of the documents that is required is a family tree which is attested by the deputy tahsildar. It is very easy to say that the family tree should be obtained from deputy tahsildar, but in practice it is not so easy. It's a little complex. The process here is you have to prepare an affidavit giving the details of the family members. It has to be attested by the notary, submit to the deputy tahsildar's office, jurisdictional deputy tahsildar's office. They are supposed to come to your house and make enquiries, and then if they satisfy, it will be attested by the deputy tahsildar. And this document is applicable only for the real estate property, because property is a state subject. At least it proves that these are all the legal rights. So these are all the unnecessary complexities that arises if a person doesn't have estate. So just a brief about Indian Succession Act for all the legal rights, which is applicable to Christians. There are so many situations here. Okay, there is no simple straight answer who have a rights in case of Indian Succession Act. Just to take 2-3 examples, if a Christian, in this case, in the case of Indian Succession Act, which is applicable to Christians, there is no difference between male and female. Okay. If such Christian is single, that is not married, all the estate of a unmarried Christian, whether male or female, father will have a rights. Inheritance rights is with the father. Christian, male or female, single, that is not married, father is also deceased, then the property goes to mother, brother and sisters, one share each. So here brothers and sisters also have a share if father is deceased. Single, both father and mother are not alive, then it goes to brothers and sisters. Fine. When I'm single, not married, it will go to my mother or brothers. I'm not worried about that. But the challenge comes. Person is married, spouse is alive. Spouse has a right only to the extent of 50% and remain 50% to the parents, kindred, children. Spouse and children are alive, only 1/3 to the spouse, 2/3 to the children. So I'm not going much into detail here. So there are so many things. I've just mentioned only 8 situations. There are so many other situations. What I mean to convey to you here is that in the absence of proper planning, so these are the complexities that arises. So most of the people are not aware about the law. Okay, they have their own perceptions, they have their own myths, and because of this, there will be disputes and disagreements in the family members in the process of inheritance. But all these things can be avoided with proper planning. So to avoid these, which we have now discussed, so these are the drawbacks of the intestate. There could be disputes, complexities, uncertainty, increased expenses in claiming the rights, distribution of assets is out of control, law will decide, and there will be confusion. It seems my audio is not there. Am I audible?
Yes, sir, you are audible.
Audible? Right, because I got some prompt here that audio connection. Hope I am going through. Is it clear what I am discussing so far?
Yeah, clear, sir.
Yeah, right. So to avoid all these drawbacks of intestate, so the next alternative is that instead of allowing the law to decide, let us decide, which is what we call estate plan. So law has made a provision. We have every right to decide about the distribution of our estate. We have every right. Law says that only when you don't decide, I will come into the picture. So what is estate plan? It is nothing but the process of setting up a clear set of instructions. You set up a clear set of instructions, but how your property or assets will you manage? This is both during your lifetime and after your lifetime. Why it is required during one's lifetime? Suppose if a person is become incapacitated to manage his assets during his life. So both are important. Estate planning is not only about the post life, even during one's life. So why it is, we will discuss going forward. The purpose of estate planning ultimately is for the smooth transfer of assets or estate to legal heirs, to avoid dispute among the legal heirs in the inheritance, to deter complexities and costs associated with the inheritance, to provide assets to the right beneficiaries so that it does not go to the people who does not need these assets, and reduce the burden on family. And that too when at a time when they require most. They do not struggle to prove the title and rights on these assets. So what is the purpose of estate plan? The next question comes, who needs estate plan? Any person who owns real estate. I've given you the example also. I own the real estate. After my life, who has a right on these assets? If I don't have an estate plan, my class 1 legal heirs. Now, who are my class 1 legal heirs? Again, we need a document to prove, which is issued by the government authority. So, to avoid all these complexities, as a owner of a real estate property, I need to execute estate plan. Single parent with minor child or children. Today in society, there are many cases where children with single parent. Could be any reason, could be disease of the parent or could be divorce, could be any other. If something happens to the single parent also during the minor age of the children, then who has a right to look after the well-being of these children? Yeah, emotionally, morally could be parents, brothers, sisters, or someone in the family members. But as per the law, they don't have a right to manage and do some transactions on the property owned by the minor children. So then someone should go to the court and legal guardian has to be appointed. So all these complexities can be deterred, can be avoided, where a single parent with minor child or children has a proper estate plan. So financially dependent spouse, parents, siblings. My father is financially dependent on me. Of course, my mother, my father, parents are financially dependent on me. So if I don't make any provisions, they don't have adequate financial security. All my assets does not belong to them because I also have my family, my wife and children. So I need to balance in distribution of assets among all my family members. If I don't do this balance, this is the reason of dispute and disagreement among the family members. Maybe I may have a sibling who is disabled, challenged. My father is deceased, he is no more. He is financially dependent on me. I love him very much. He is my brother. If something happens to me, he being a brother does not have any claim on my assets. It belongs to my class 1 legal heir. My brother is not my class 1 legal heir.
So you're not so audible. Sir, you're not audible. Is he audible?
Suresh, staff.
Though they have enough assets, they're not able to access these because of the lack of proper planning. And most important is where spouse is incapable of managing the estate. When I'm saying incapable, I'm not looking at them down. We have come across in India many women at home are typical housewives. They take care of house very well, management of children, upbringing of children. Absolutely, they support husband in all the aspects. I respect them a lot, but they may not be savvy financially to manage like you and me are. They may not be knowing about the management of investments.
So audible that time.
So in such case, if you give property worth lakhs and crores, and she is not able to manage it, and she depends upon the advice given by the people around her, and this advice may not be suitable to her. In fact, this is one of the reasons I say to every client who come for estate planning, the first recommendation I give to them is that every client should have a trusted financial planner who can assist them in managing their finances and introduce this financial planner to the family members. So when you're working with your financial planner or advisor closely, you both understand the requirement each other. So in the absence of the investor, financial planner can guide the family members in the right direction. So family members should have the kind of trust and confidence on the financial planner. This has to be built by yourself. Believe me, again, I have experienced it when after the remains of the person, all these wealth created by a very disciplined investor is misappropriated by the family members. I am sure you also have come across in many cases. Then other case where the person needs estate planning is coupled with no children. Today in society there are many people, couple, they both live together. What happens if they are not there? And any family member with specific needs like disabled brother, parent or whatever, if any specific needs. So these are the people more significantly, they need estate plan. So other thing when it comes to estate planning, many think that my estate is not big. There is no need to have a estate plan. I don't need a estate plan. It is a myth. It is not how big or small your asset is for the estate planning. It is how value this asset is for your family member. For me, a lakh of rupee or 10 lakh of rupees is not big. Let us take the current COVID scenario, lockdown. Yeah, most of us are able to survive for the next 2 months, 3 months, 5 months, even if you don't get a salary. We're getting a salary of, let us say, 1.5, 2 lakhs per month, even though there's a loss of income of 6 to 10 lakhs for the next 3-4 months. Yeah, there is a loss of income, small pain, but it does not affect our standards of life. But there are people who are suffering too. For these people, this 8 lakhs is equal to 8 crores or 80 crores. Similarly, the property where I live in, for me, it may not be bad, but for my parents, if I leave this property to them, it's a big moral booster for them that, yeah, they have a secure place to live. For me, 10 lakhs is not a big amount, but I leave 10 lakhs to my parents, they can live for the next 10 years on this 10 lakh rupees. Their life is secure. So let us not look into it, how big the asset is for us to have estate plan, but it's how important, critical for our family member so that they enjoy the benefits of these assets. So now, what are the tools for estate plan? How do we do estate? We can make a will, which most of the people know about this. By making a will, we can transfer the property. But many think that estate planning is only will. But there is beyond that. Estate planning is even beyond will. We can also have a family trust to protect the property and provide benefits of the property to family members by creating a trust. And we can have a power of attorney, which will help you to reach where you cannot reach. So these are the tools that can be used in estate planning. The purpose and the objective of each of these instruments is different. When you make a will, it enables you to transfer the property or assets owned by you absolutely to the family members after your lifetime. There is absolute transfer of asset. But when you create a family trust, the asset is not transferred absolutely to the family members. Only you make a provision to transfer the benefits of this property to family members. Your asset is protected for future generations. And power of attorney, which will help you to appoint an attorney or an agent to do certain things on behalf of you when you're not able to do it. So all these three are important. Now, which is necessary? It is subjective. You have to have proper counseling, consultation, understand what are your needs, assets you own, and then decide. Yeah, there are cases where a simple will is sufficient. There are cases we say that will is useless. There is no point in having a will. You should go for a trust. And there are cases we say both will, trust, power of attorney, all are required. So there is no one simple straight answer that which is the right instrument to have an estate. So many think that will is the only instrument. They make a will, and ultimately it is of no use. So power of attorney will help you to operate the bank accounts, investments, even to do the transactions on the property, buy and sell the property. So when a person is not able to present himself to carry out these transactions, he can authorize another person to operate these investments. This is what is the purpose of power of attorney. Will help you to transfer, bequeath, and give away your property absolutely to a specific individual. So a family trust is an arrangement. A family trust is an arrangement. So here, a person, let us say, for example, you yourself here, you create a trust. How can you create a trust? You need to transfer some property in the name of the trust. This property could be anything. It could be money, it could be real estate, it could be gold, it could be anything which has a value. You can start a family trust even with a small amount of, let us say, 5,000, 10,000, 20,000. So how do we create a trust? There is a trust deed which has to be drafted, which will be done by the estate planners or the advocate. So we'll understand the needs for which the family trust is created, the purpose and objective of family trust. According to the deed will be drafted. There is no one draft fit for all here. Okay. And this deed will be registered. So when an entity has come into existence under the provisions of law, we give a name to the trust. In the name of the trust, you can apply PAN from the income tax department. Once you get a PAN, you can open an account in the name of the trust with the PAN number. And trust can accumulate funds and assets. All the assets will be in the name of the trust. To manage this trust, we can appoint trustees. Trustees are those people on whom we have a trust and confidence that they will be able to manage the assets efficiently and effectively. And whatever income that is generated by the trust on these assets will be provided to family members who are known as beneficiaries. So here we are making an arrangement where properties and assets are managed by professionals or a persons who have a capabilities and capacities to manage the property and provide the benefits to the family members. So these are the three instruments we have, which we can use in estate planning. So we are all understood that life and death is a reality. We know that we have to accept this truth and act upon this truth. This is what in brief about the technical aspects I thought I'll convey to you, and next we can take in the Q&As. So I am here now. I will talk about myself. I am here as a chartered trust and estate planner. I am certified by the American Academy of Financial Management. I am practicing trust and estate planner. Okay, my focus is only to guide the people in having a proper and appropriate succession planning. And I also guide and assist the people in the event if a person left this world without an estate plan. So I help them in complexities of all these inheritance and ensure that property is distributed. This is my primary work. And I work with the people like Manita and all so that they can add value to their clients. So my office is in near Southern Circle, Harbour Road, close to Southern Metro Station. We call it propseva, okay, property services. We are ISO 9001 2015 certified company. So you are all about know about cPROFIT. You have been associated with cPROFIT for a quite long time, and Vanita is one of the passionate financial planner. I know her for so many years. and her appetite to gain knowledge and add value to her clients. I really appreciate that. Because of this, again, she arranged this webinar to you for the benefit of you. She has some goodies to share with you all. She is going to share with you ebook. I think you can download. It's already shared. I think if I'm right, Sushma. You have
That's
an ebook which gives you a little more details about estate planning, which Vanita will share with you all. Okay. Vanita has requested me because during the webinar we may not have an opportunity to have one-to-one interaction to address the unique and specific queries by each individual. Okay, she requested me to take out some time during this lockdown period. Yeah, I also offer you to give my time for 30 minutes one-to-one interaction to answer your queries and specific questions. Provided you confirm to Vanita well in advance in the next 30 minutes so that we can have a proper schedule at a mutually convenient time. We can connect over the phone, we can connect over the Skype, or we can connect over the WhatsApp or email or whatever.